month, October, is a National Estate Awareness Month. And this is a time when people should be thinking about their estate and why they should have a will or a trust. I'm very honored today to have Rachel Schromen here. She's an attorney in St. Paul, an estate planning attorney. She's been honored by many magazines and newspapers. And so we're very lucky to have her here. So I'm going to turn it over to her, and then I'll talk a little bit later on about some other things.
So we're going to talk about estate planning at a macro level, talk about the different documents that comprise an estate plan and the different considerations that come into play when people are deciding what documents meet their needs best and or what decisions to make in the documents themselves. Now, I always start very basic with covering what is an estate in the first place. We had a question here if the slides will be available, and yes, they will be sent out with the recording of this. Okay, so when my mind is the sprawling lawns behind my favorite palace in Vienna, Austria, Schönbrunn Palace, and there's a lot of wealth. And in fact, a lot of times when I meet individuals and I introduce myself and say I'm an estate planning attorney, they respond and say, well, we'll need one of you eventually when we have an estate. But for purposes of Minnesota law, an estate is really simply your stuff. The value doesn't matter. Now, the value can matter for tax planning purposes and other considerations. But no matter the size of the estate, these things still come into play when it comes to planning in terms of a person doing their estate planning. So bank accounts are part of your estate. It doesn't matter if there's $1,000 in your bank account or $100,000 in your bank account. And when I refer to real estate, it can have a mortgage on it. A lot of times people say, well, we don't own our house, the bank does. Well, usually have at least some equity in the home. And what we're planning for is that equity, whether, again, it be a few $1,000s or half of the value of the house. Any stocks, bonds, and investments are part of your estate, vehicles, jewelry and personal property, retirement accounts are also part of your estate. And when I work with clients, we talk about planning for care of pets. And then interest in assets that you have or that you're passing on. So life insurance, securities, dividends, those types of things are all part of the big picture when we're looking at estate planning. Estate planning is simply the process by which you specify what happens with your assets, not only after you pass away, but also while you're alive. So the documents that typically comprise a full estate plan are a will and or a trust. We'll talk about those in more detail later, but also a power of attorney and healthcare directive. Now the will and the trust are going to have all the information that says this is what happens after I pass away, whenever that might be. The power of attorney and healthcare directive, those come into play while we're still alive. But say something happens and we need help managing our finances. We need someone to make a decision, file our taxes for us, make medical decisions on our behalf. Things that are thought about when going through the estate planning process. When you have these documents, you can give legal force to your wishes concerning guardianship of minors, who the heirs of your estate are going to be, and who would make your financial and or medical decisions if you can't make them yourself. Those are kind of the high level items. Of course, there's a lot more, and we are going to get into more detail. Why have an estate plan? So it's first important to understand what happens if you don't have an estate plan. And we're going to cover this in length. When I meet with clients, what it really comes down to is a client comes in and says, do I need this document? Oh, no one needs to do anything. What will happen if they don't have that document in place? And if they don't like that, and they want something different to happen, for estate planning comes into play. I used to do pretty frequent seminars with a financial planning firm pre-COVID, and the financial planner kind of started every seminar with a shtick, and he would have everyone in the room, he'd say, raise your hand if you have an estate plan. Because with these seminars, there are a lot of people who are starting from no documents at all, but there's a good number of people that they've done something maybe 20 years ago, they might need to update or change it or look at it again. So he'd ask, who here has an estate plan? And a few of the people would raise their hand and he'd look around like, you know, he was really counting. He'd say, okay, wrong. You all do in the state of Minnesota for you. So what he was referencing was what Minnesota calls intestacy statutes. And what intestacy means is that the person died without any estate planning documents in place. They died intestate. Laws that step in and say, okay, there's no plan here, so here's what we're going to do. And those laws will dictate how a person's assets pass. There's a good chance that the estate will end up in probate court. And probate court is a specialty kind of court that exists to pass assets after someone passes away. Judges will look to the state laws to determine what happens from there. So we have laws that say, okay, where do these assets go? Well, if you had a surviving spouse, everything will go to your spouse. Maybe, assuming you don't have children from a prior relationship, or there's a number of factors that can muddle that. If you don't have a surviving spouse, equally to your children. If you don't have children, your parents. If you don't have parents, your siblings, and it branches out from there. I had a probate recently where we were reaching out to third cousins, trying to find family to do something with these assets. It was a very interesting case. When there are individuals who pass away and leave minor children, ultimately a judge will decide who should have guardianship of the children. What happens is there's a guardianship hearing, someone will petition the court to get guardianship, but in the event multiple people petition, well, now the judge is hearing the case and deciding who's best. Done ahead of time, you say where your assets go. You nominate who you want to take care of your children. You're really stepping into your power to have that lined up and out for your family. There are tax implications, and Cindy will cover that in more depth. It's dependent on estate size, and as of this year, Minnesota estate tax. What that means is for an individual, anything over the amount of $3 million is subject to tax. We don't have what's called automatic portability between spouses. And all I will say on that topic is when I meet with a couple and they're still right around that 3 million mark or over it, there is still some tax planning to be done. Just because you're married doesn't mean without planning you're automatically going to get this 6 million. And during your life, if you were to become incapacitated, whether that's due to illness, a car accident, age, anything, and you need someone to make financial decisions or medical decisions on your behalf, your family could find themselves having to become a court-appointed guardian and or conservator over you to have the legal authority to make those decisions. And I'll give some real life examples actually from my personal life when we talk about powers of attorney and healthcare directives. Now, Cindy is going to talk about gifting and some of the tax components.
So gifting has become very important in the last, to a lot of people in the last year. There's been a lot of talk about changing some of the exemption rules. Well, what is gifting? Gifting is giving away your assets, we talked about that, to other people, your children, your other relatives, friends, during your lifetime to lower the value of your estate. So what's been coming into play in the last year or so is that at this point, it's 11.7 million for a lifetime exemption. Buckets, I call, of gifting. There's the annual exclusion, and I think everybody is aware of that. You can give $15,000 to any one person every year, and you do not use up your lifetime exclusion. So what happens when you go over that 15,000 a year? And remember, for a couple, it's 30,000. Well, then you would have to file a tax return. Okay. I do want to point out very quickly, the person receiving the gift does not have tax. It's the person who gives the gift. If they go over their exclusion, that would be required to pay the tax. So when we talk about this bucket, this lifetime exclusion, this is what is going to be changing potentially as of the 1st of January, 2022. Right now, you can give up to this amount, and there would be no gift tax. What they're saying is, if you use this 11.7 million before the end of 2021, it's kind of a use it or lose it scenario. Then in next year, it may go down to what they're thinking of right around $6 million. So that means that right now you have 11.7 million that you can give away before you would be taxed. Next year, it's going to go back potentially to $6 million. And that's why it's important to talk about gifting now. If you have an estate that's larger, you want to think about estate planning before the end of the year. It's getting very close. And there's other ways you can gift money besides just cash or whatever. There's other ways to do that. Also, there has been talk, if I decide to give $11.7 million this year, I'm going to use up my exclusion in 2021. If I die in 2022, are they going to claw that back in? Or are they going to say, oh, no, we changed our mind, it's only 6 million? No, they have said, and everything, nothing is ever 100%, that they will not claw that back. And you will not be faced with that if you would die after that year. The types of gifts. People frequently ask me, well, what can I do? I have an estate. I have a large estate. I want to get it down to, let's say, the Minnesota exclusion amount, which is 3 million. Well, there's ways that you can help your family and not use up your exclusion at all, even your $15,000 exclusion. One is to pay tuition or medical expenses directly to the organization for, say, your grandchildren. Maybe you have a relative who has very high medical expenses. You can pay directly to the medical institution. That would not use up your annual exclusion of $15,000. Gifts to your spouse, those are not included. You can give, that's not included in your annual exclusion amount. And you can also give to political organizations. But note that most political organizations are not charitable deductions, but a lot of times people will like to give to a political organization, as a gift. So these are things that are excludable from that annual exclusion. And also, people will ask me, well, what is a gift? What do I give? What could I give to somebody that would require me to file a gift return? If you gave money to your grandchild, they want a new car, they want to take a trip around the world, and you give them money, that's a gift. You have to file a gift tax return if it's over the 15,000 exemption. If you decide you're going to lend money to somebody, okay, I'm going to lend my friend $100,000 interest-free. That's a gift. Loan. Let's say I decide to lend you money. You're going to pay me interest, and after a couple of years, you don't pay me back. I just say, forget it. That's a gift. So let's say that, and this is a kind of a tricky one. If somebody says, I'm going to put you as a joint on my account. Well, now you have access to that money. If it's a significant amount of money, that's a gift. And so a grandparent, if they contribute a large amount of money to a 529 plan for their grandchild, that's considered a gift. But there is a special rule, and this is something you can talk to us about, where you can super fund a 529 plan over 5 years. And it's very important to know, if you say have 5 grandchildren, you're looking for a way to lower your estate, you can give up to $750,000 or $750,000 and super fund grandchildren 529 plans in 1 year. So that's another way of lowering your estate, but also not having to pay any estate tax.
Mm-hmm. I want to make sure I understand on that.
Right.
The gift is just the interest.
It's the interest, right? Okay. Yes. So it's you have to be very, very careful about, giving, and, if you give your son a car or something like that, be very careful to keep track of your gifting every year. Sorry, technical difficulties. That's why we have Kim here. Process of estate planning. Well, it's a team. We will promote the team. It's you, and you decide you want an estate plan. You have an attorney, you have a CPA, you have an investment advisor. You choose somebody to be your trustee. You choose somebody to be your personal representative. This is your team who you're going to use. And it's important to go to the team members that specialize in that field. If somebody comes to me and asks me legal questions about writing a trust or a will, I will refer them to an attorney. And attorneys do the same. If there's tax questions, they say, well, talk to your CPA. So I'm going to turn this over to Rachel now.
Thank you. By saying, from an attorney's perspective, especially the CPA, the attorney, and the financial planner, when you're working with these professionals, we're all trained very differently, and we look at things through a different magnifying glass. So I'll use the example of putting a grandchild on your account jointly. If a client comes into me and says, I have this one checking account, that's all I really have left, I want to make sure it goes to my granddaughter in a very simple, easy way. There's a number of ways to do that. And if they say, could I put her on as a joint owner? Well, from a legal perspective, yeah, that's a really easy way to meet her goal, her legal goal that she's, but if Cindy was working with that client, she would have a different lens, and she'd be looking at, okay, financial planner might say, why do you have $100,000 in your bank account? We could be making that money productive. It's so important to have a team, because there's a lot of times that I've been doing very comprehensive planning for clients. I'm there to deliver legal options and more of a legal education to support them in making decisions that will meet their goals. The CPA might have a different perspective. The financial advisor might have a different perspective. And all that team is really there to do is support you in choosing what meets your needs and goals most efficiently and cost effectively in the short term and or the long term. We covered this already a little bit about what happens if you don't have a will. I'll expand a little further. We talked about probate court. So in Minnesota, probates can be required depending on what the estate looks like. And what triggers or requires probate is if the estate has property. So if there's a home or land or a cabin that there hasn't been planning done with prior, and or if there are assets without any other beneficiary designation that add up to over $75,000. So I'll give an example. I had a woman retain me. Her husband had just passed away, and he had a trust set up. They had really, I didn't done it years before I was even in college, frankly. But the trust was done really, really well. It was all set up, good to go. He passed away and he was a part owner in a family business. Now, the family business had a prescribed formula as to how his survivors would be paid, how his shares would be valued, etc. And the business paid $250,000 to his estate. The probate process in order to get that $250,000 to his spouse. Let's say I have a client come in and they have a trust set up that owns their house. They have a bunch of life insurance and retirement. Beneficiaries are set on that, but they have $75,001 in a bank account with nothing done to the bank account. So when you're working with an attorney, part of my role is to walk through what your assets are, identify what your goals are, and help you know what to do with what to avoid probate if that's your goal. Now, probate isn't always bad. In fact, sometimes probate is an ideal option. When I have families that there's a lot of dispute, there's potential for a lot of argument, and maybe they don't have someone that they trust will do everything up to T. It's not a bad idea to have a judge's eyes on everything as it goes through. Well, sometimes it's not a bad idea to keep it out of court so people can't fight. This is where it gets very, very fact specific. For clients that have, maybe they have smaller estates and they don't want to spend a lot on estate planning now, but when they pass away, the estate's going to get all this life insurance that can be used to pay for probate. Sometimes that becomes an ideal approach. So those are just a couple examples, but it does become very fact specific. And I don't like to give off the impression that probate should always be avoided at any cost. And it's horrible, horrible, horrible. But it does serve a very important purpose. The state uses the laws to distribute your assets, make determinations regarding guardianship of children. If there's no personal representative or executor that's been named in your documents already, someone's going to have to step forward and show they have priority to be named, and the court's going to have to sign off on that. So that can become an issue if you have 3 children who all want to be the personal representative, and they all petition the court. And then all this does is add time, expense, delay. It can be. This process is longer because the probate process is longer because it requires court hearings. And I'm going to take this even a level deeper into the weeds. In Minnesota, there's 2 types of probate. So there's formal probate and informal. If someone dies and they don't have a will, it's automatically a formal probate. And this requires hearings in front of a judge. So I'll give an example. Let's say a client calls me and says, my parents passed away. We have a house that we need to sell. They didn't do any planning ahead of time. Okay, we need to open a probate because you need to sell the home. So they're going to meet with me. I'm going to prepare all the documents. That'll take a couple weeks. We'll get it filed with the court, and then the court will set a hearing in 4 to 6 weeks. Lately, it's been more like 6 to 8 weeks. Once we have that hearing, there's also a 4-month period where the court allows creditors to bring forward claims. So that adds on more time. When I have a client that has that situation, they just need to sell the house, parents are deceased. If we go through probate, let's say they call me, when can we get this house listed? Well, start on getting it ready, but maybe contact a realtor in a few months. If it's held in a trust or there was a transfer on death deed or other planning that exists which can avoid probate, I say, you need a referral, you can call the realtor and hang up with me. It goes that much quicker. So we had a question asking, If a person has minor children, will there have to be a court process to get guardians legally appointed, whether there is a will or not? The answer is yes, because that legal guardianship needs to be appointed by the court. The difference is when there's a will, it nominates who you want that to be and makes that process quicker, more expedient, and also more likely to be in line with what your wishes are. Okay, thank you. All right, so some of these slides, how these are designed is they essentially walk through what my or any attorney's intake packet looks like. And I present it this way for two reasons. One, we can get a lot of information in while we go through. Two, it explains to you what attorneys are looking for and why. And then the goal is that when you do sit down to do this planning, it's going to take you about half the time to work through the worksheet and take those next steps. The packet always says, what is your name? We are looking for full legal names. I have had, kind of surprisingly, a number of issues around this. So I had a gentleman who, I'm going to use a name of makeup. So his name was, he came in, he wrote down John Wilson Sr. Okay, so I do all the documents, John Wilson Sr., get everything signed. And about 2 days later, they reach out and they go, yeah, so we're looking. He doesn't have senior on anything, which makes sense because you're not necessarily born a senior. I said, okay, is it on his bank accounts? Is it on his driver's license? No, we don't use senior anywhere. Well, that was important for me to know. Another example would be a client whose name is Eugene John Wilson, but he goes by John his whole life, dropped Eugene when he was like 6. Well, if Eugene John Wilson is still that person's legal name, I need to know that. If that person's name is Eugene John Wilson, but they go by Pete, we'll put in AKAs. If I work with a female client and her last name, say, is hyphenated, it's important for me to know, is it, Schromen hyphen Wilson or Schromen space Wilson? We'll always ask about citizenship. It's important for us to know the citizenship status of our clients. My tax advice and a CPA's tax advice and advice around legal documents will differ if my client is a US citizen, a permanent resident, if they're here on a visa, like a B visa for business and going through the citizenship process, or if they're here as an undocumented citizen. And I've worked with all different statuses. Advice in terms of what the client needs does differ. So that's very important to communicate. If you have been divorced or signed a prenuptial agreement or postnuptial agreement, a lot of times I will want to look at those, especially if there's minor children. It's not uncommon that divorce decrees might have some requirements in them regarding the minor children and child support, for example, that impacts my advice for what I can do in the documents. And prenuptial agreements almost always will address retirement, or not retirement, and what those people will do or what they can do. And I want to make sure I look at those so my advice isn't going against a court decree or existing contract. I also always ask, who are your professionals? There will be a spot, who's your CPA? Who's your financial planner? If clients don't have one, or if they don't fill that out, I ask if they have one. If they don't, I'm usually making a referral because, again, we want that team approach. And then I also ask about family members and their contact information. Again, full legal names. And then with the contact information, when you sign your documents, the addresses and or phone numbers that go in some of the documents just need to be the current legal contact information at the time of signing. So sometimes I get the question, well, my son's in college, he moves every year. Do we need to update this every year? Each time, like we'll talk through it, but I have yet to update like a power of attorney or healthcare directive only because an address changed. And then I always ask for a list of assets. I'm not looking at your assets to try to gauge what I can charge. That is not how most attorneys work. What I'm looking at is what type of asset do you have? Are we talking about beneficiary designations? Are we talking about deeds? What do we need to discuss in terms of estate planning? And then also the general size, because again, it's important for me to know if there's a need for potential estate tax planning. Of course, we'll talk through your beneficiaries, and it's important to also know that as an estate planning attorney, I will always ask, what if? So a lot of times clients come in and they say, if I pass away, I want everything to go to my spouse. We both pass away equally to our children. Next question is, okay, what if your children don't survive you? Or you all take a cruise together? We're always going to that next what if. At some point, we have enough backups, but think along those lines. I had a couple come in once. They were a younger couple and they had children that were like 5 and 3. And they said, yep, we want everything to go to our kids. Okay, what if your kids predecease you or like you all die in a car accident? And I shouldn't laugh. The wife looked at me in horror and then started sobbing. She had never thought of that possibility. Through it, we came up with some backups, but I started talking about that ahead of time in seminars to just kind of prep people for some pretty hypotheticals that we sometimes have to walk through. And is a very important piece. Whenever I meet with clients, I'm looking at the ages of their children. Do we need to talk about guardianship nominations? If clients have younger children, say teenagers or even younger, do we need to talk about at what age or ages do you want assets distributed outright? And what I'll tell you is, if there is no will and or you have a basic will, what happens is through the probate guardianship process, the court will assist in setting up what's called an UTMA account. And UTMA stands for Uniform Transfer to Minors Act. That account is established for the minor. That minor's inheritance can go in it. You can nominate who you want to be custodian of that account to manage the funds, pay out for things that child might need. And when that child turns 21 is typically when they will receive those assets. So I have some clients that come in and they go, oh my gosh, my son's 20 and under no circumstances should he have a large amount of money within a year. We need his brain to develop a little more. So with trust planning, you can do things, you can set up a trust and say, okay, if I pass away, I want my money to go to be held in a trust for my son. Ask the trustee for disbursements. The trustee can pay out for health, education, maintenance, and other support, which is pretty broad. And he can have a third of it when he turns 26. You can give him half of the remainder outright when he's 30 and the rest when he's 35. It's kind of stepping that out. So if you do have a 26-year-old that gets a lump sum of money and goes out and buys a brand new Tesla and then realizes, wow, that felt really good for about a week, realize all the money was gone. Maybe when they get the next in their 30s, they'll invest some of it. Training wheels on with that. A little bit, because on that topic of trust for children, if you have special concerns around children, so if you have a child that has special needs, and kind of what the threshold is in talking about special needs planning is if that child is currently receiving or expected to receive Social Security and or medical assistance. It's important to have additional planning so that you can still pass money to that child without it impacting the benefits that they're entitled to and receiving from the state. If you have a child who struggles with addiction, substance use disorder, or mental health, you can also have specialized trusts set up that really speak to that and kind of come up with a plan where that inheritance can be used to really support that child in their health and success and recovery rather than enabling their disease, addiction, or use. This I'll give a note. This is an area that I specialize in. In fact, I do statewide trainings to other attorneys. It's important to bring up to your attorney because it can be an important part of your planning. And at a very minimum, having a discussion about what's possible and then deciding if you want to go that more stringent kind of detailed route. If you have made an advance to a child, so say a client has 3 children, they paid for 2 of them to go through college, and then the 3rd one had scholarships the whole way, and they kind of want that to even out on the back end, those types of advances on inheritance can be worked in. I had a client once who had 2 daughters. One of his daughters struggled with substance use disorder and had mental health challenges, and he had, gifted her and supported her 100. And so at the time he passed away, and I updated his documents about 6 months before he did, money was kind of deducted from her share of the inheritance because he said, well, I've given her all this money. I view it as part of her inheritance. She just got it ahead of time. That can be done with estate planning. If you plan to treat your children unequally in your inheritance, bring it up. If you want to have that conversation, and I will say, not mean unfairly. I have so many clients that are not distributing things in even amounts to each child, that disinherit a child. It's more common than I thought it was going to be. And I will first say that my clients never need to give me a reason or valid explanation as to why they're making that choice. If someone came into me and said, my youngest daughter just really annoys me and I don't want to leave her anything, I don't like her, I wouldn't. It's their money, their decision. What I will say is most clients that come in, there is a backstory and there's a lot of thought and reason that go into these decisions. We've helped this child more. This child doesn't manage money well. This child's been estranged for 6 years and stole from us for years. I mean, there's so many things. And again, even just having the conversation and knowing your options is a good thing to do. Guardians. I always tell people, of course, you can name relatives as guardians, but also friends. If you don't have a relative who can act, maybe you have a close family friend. If your child has a godparent, that godparent is not legally going to be the next guardian. And I did not know this was a common myth until my husband and I, my sister-in-law had her first child, and so it was our first niece. And I got home from work, and my husband kind of rushed me and sat me down. He said, I need something really okay. And he said, Katie called, and she asked if we'll be the baby's godparents. Great. I hadn't been married to him that long, so I was like really touched. And he just yes like that. I said, yeah. California for a baptism? He said, no. If something happens to Katie and Nick, then if we're the godparents, we'll get a baby. So that's why, my Uncle Tom was our godfather because my parents wanted us to go to him if something happened. I said, well, no, we won't. Not because I don't want to, but like, let's talk about legally what they need to do for naming guardians. And so I started talking about this in seminars and found out it's more common of a belief than I thought. Animals, I'll keep this brief. That is my dog, Mabel May. She's a therapy dog. She works in hospice. Well, she and I work in hospice and with children with autism, so it's one of my clients' children. We do plan for pets. Under Minnesota law, they are personal property. What makes them a little more challenging is their living personal property. And when I've worked with people distributing an estate or doing a trust administration, there can be a lot of stress and anxiety around pets when there isn't a plan ahead of time. So at a minimum, your will can say, hey, I want the personal representative to rehome the pet. Reach out to the German Shepherd Rescue that we got these dogs from. It should go back to the German Shepherd Rescue. Gifts for cash care of the pet if you want to. A brief example of that. My older brother took my dogs. He can take a couple dogs, get them to the vet, buy food and a bed. My little brother took my dogs. He would need a little bit of money to kind of absorb that additional expense at the beginning. And you can set up pets for the care of your, or set up trusts for the care of your pets. I've only done 2. And what this example is I'll use one client. She came in, never married, no children, and her just animal lover, and her dogs were her life. And so when she passed away, all of her money went into this trust where it was held and invested and grew money. And the money in there could only be used to pay for the dog's needs because she wanted to make sure their food was kept up. And I mean, they were some pretty pampered dogs, so they weren't cheap. When the dogs pass away, that trust is going to 3 different animal type charities. So I don't get a lot of these, but I like to talk about them. And or a trustee. Another kind of blanket term for this is executor. A personal representative is the person that's named in your will, and the trustee is the person who's named to act on it. It's like pay your final debts, file your final taxes, collect assets and distribute them in accordance to what your documents say. You want to pick someone who's trustworthy and responsible, of course. And the personality type, I always like to describe the ideal person to name or who that person might be in your life. The person you know who, if there's a family emergency, they're organizing the meal train, they're letting everyone know what's happening when, they're bringing a change of clothes to the hospital, they go into action mode. They're very good people for this role because they like to get things done, step up and help. And not only does that speak to their character, and I can say this because I'm one of these people, but oftentimes for that person, that's how they're coping and managing in that situation. Stepping up, being useful, providing care, getting things done. When we talk through assets, again, I'm looking for taxable estates, potential tax issues, the nature of how you should be passing things on, but then also how assets are held. So I had a client come in recently, and when I send out an asset inventory, it's like a chart, and it says spouse 1, spouse 2, joint. And they filled everything out in the joint column. They had been married, 40 years. Everything was considered joint, but I know their retirement accounts aren't joint because they can't. So we went through and we delineated, all right, what is the breakup here? And what I found out through that was the house was in spouse 2's name, the wife, and his name actually wasn't on it. That's very important for me to know because if she passed away, he'd be gone through probate to get that house into his name. So we did a transfer on death deed, made it simple to plan for that. But I was very, very glad that I was on my A game that day and took the time to go through that. So when you do fill out those asset inventories, it's very important to delineate who owns what and what is actually joint. A will, we're going to get into talk about wills and trusts. So a will is kind of a basic document that still provides a really comprehensive approach to your estate plan. It's really a cornerstone of building an estate plan. It's ideal for estates that do not have any tax issues, able to designate who the beneficiaries of the estate are, nominate who the personal representative would be, nominate guardians of minor children and custodian of accounts that might pass to a minor. With a will, as long as your family has the original, like the ink signed copy, it likely will be an informal probate if probate's required. Means less hoops to jump through, less expense, less time. And I always note, you can have trust drafted into a will. That's about as far into that as I go, because when it comes into trust planning, that's a very fact-specific conversation. But inevitably, when I don't mention having trust in a will, someone asks, can't you have trust in a will? Yes, you can. The trust can still pop up after you pass for the children. But again, if they're in a will, then you have to push everything through your estate through the probate. So it's really important with trust planning that you work with an attorney that can really talk you through, here are the options and what that looks like and the different pros and cons. up from wills in that they're more comprehensive. They provide more control. Now, a trust is a legal agreement in which a trustee holds and manages property for another's benefit. I read that the first time and went, what? So I'm going to explain it in a more English way. Come in that say, well, I don't want to trust because I want to keep my property while I'm alive. I don't want to trust because I don't want a trustee to decide what happens with everything after I pass. Trust is when a trust is created, really what we're doing is creating a bucket to hold. So rather than me owning my house in my name, Rachel Schromen, I own it as trustee of my trust. I put it in my bucket. Apply to other assets. While I'm alive, I hold my own bucket. I can reach into it, take things out, put them in. I can change the terms of the trust or what the bucket looks like. I can do all of that while I'm alive. If I pass away and Cindy now is the next trustee, the bucket's going to pass to Cindy. Now she holds it. But she can't take things out and put them back willy-nilly. She has to do it based on the terms of the trust. So if Cindy's the trustee, but my niece is the beneficiary, she's holding those assets for the benefit of my beneficiary. Estate tax planning. There's a number of ways to do this. That's its whole own hour-long seminar. You can provide for control and protection of assets. We talked about spacing out distributions, for example, having addiction or mental health planning in there. That can be done with trusts. Trusts are a way to avoid probate. They're not the only way. I have clients who have estate plans that avoid probate that have wills. We utilize transfer on death deeds. We utilize beneficiary designations. This gets fact specific. And again, when I meet with clients, I'm looking at what is the most efficient and cost-effective way to meet your goal. That can be a relatively simpler approach. I talked about even the example of selling the house, and they can be a very ideal approach for blended families. A lot of times with blended families, let's say I have a couple come in, they've both been married before, have children from a prior relationship. Their plan doesn't always look like I want everything to go to my spouse and then our kids equally. It gets a little more complex, which frankly, in 2021 is the majority of the planning I do. Trust really be a good tool to encompass that more comprehensive, complex planning. In states, it's important to know that property has to be probated in the state it is in. So I will give you the example of my mother. She owns property in Iowa, Illinois, some land in Wisconsin, and they have a house in Florida. When I was in law school and I realized property had birthday and Christmas for 5 years until she got it done, because I went, oh my God, I do not want to handle probates in this many states. So her trust can own all these different properties. Now we avoided probate in those states. Naming beneficiaries, again, you want to think about who and what percentages, back up to those people. If you want to do charitable giving in your estate plan, you can do this very easily through beneficiaries. And then personal property can be passed by a written list that you sign and date and just keep with your will. Some people have certain things they want in the formal will, but having that separate list that's legally incorporated into the will makes it very easy for you to update and change as your stuff changes throughout your life. The last two documents we're going to talk about, power of attorney and healthcare directive. Now, power of attorney is the document where you name who has legal authority to step in and make financial decisions on your behalf, manage your finances if you're alive. A lot of people come into me and they say, I need a power of attorney and make sure it's durable. I'm going to explain what a durable power of attorney is and kind of how these work, because it goes against what common belief is and what I thought going into law school. So a power of attorney is actually effective when you sign it. What makes it durable is that you will authorize it to stay effective in the event you become incapacitated. So it works a little backwards from what people think. Still a great document to have done. Also a good document to not distribute copies of or leave laying around your house. You want to keep it safe while you're alive. People should know how and where to get it when and if they need it. The person named to act can be authorized to gift themselves money or pay for things on their behalf or not. A lot of times spouses will allow their other spouse to do that, but beyond that, the people acting shouldn't need to gift themselves money. You can require that the person acting to manage your finances make an accounting to you and maybe a third party. Some people like that for a system of checks and balances. Others like that, or others think it's an unnecessary extra hassle to have in place. So without a power of attorney, your family can find themselves having to initiate guardianship or conservatorship proceedings. Example of this. So about 2.5 years ago, my older brother, 40 years old, seriously had just had a physical and checked out perfect health. And then he got a virus that attacked his brain. And that is not something to Google before bed because it's frightening how easily this can happen. He got this virus, it attacked his brain, and he was in the ICU for 6 weeks. And while he was in the ICU, at first, the doctors were telling everyone, like, he's definitely going to die. He didn't. Then he was preparing us that he would be severely and permanently mentally incapacitated the rest of his life. Now, I'll give you the ending because sometimes I forget and it stresses people out. He did miraculously recover and he's fine now. But during this time, we didn't know. And his spouse was handling, considering, and she called me one night and she said, Rachel, I'm running into these issues. His employer won't talk to me about his short or long-term disability. The mortgage lender won't answer questions. We had separate bank accounts and then we contributed monthly to a joint. I can't access any money in a separate account. Everyone keeps telling me I need power of attorney. Can you tell me how I can do that? Well, she couldn't. Once he lost capacity, he can't sign. So I had to tell her over the phone that I recommend that you reach out to an attorney that does guardianship and conservatorship in Iowa. And that was the first time she hysterically broke down. Of course. And, I know this stuff as a lawyer and I study it in school and I see it with clients. It is a different level of heartbreaking when it happens in your own family. And it really made me emotional time, but not having a power of attorney turns into a legal pain in the butt, but it is emotionally crushing to have to go through that while you don't know if your spouse is going to pass away or have to go into a care facility. And it was horrible. So luckily he did regain capacity and guess what? She had him sign shortly after. Power of attorney. Okay. Healthcare directive, similar to the power of attorney. This is the document where you authorize who can make your medical decisions. Again, if you're alive, if you can't make your own. If you can make your own medical decisions, the doctor is always going to refer to you. If you can't, then they will refer to the person you've named. And I will note, because I forgot to state on the last slide, your spouses are not inherently authorized to access your bank accounts or make your medical decisions. So for example, if I didn't have a power of attorney and I got in a car accident and my husband went to the bank and said, I need money out of Rachel's account, there's no way he's going to get access to that. No. I've authorized him to access that when he needs to. With the healthcare directive, the same thing comes into play. And a good example of this is Terry Schiavo. And I think all of us are old enough to remember Terry Schiavo. So it happened when I was young, but this was a woman who in her 20s, I believe she had a heart attack and she ended up permanently in a vegetative state. She was being kept alive by artificial hydration, nutrition, and artificial life support. And her husband said, Terry would not have wanted to live this way. Please remove all the artificial things keeping her alive. Parents and said, absolutely not. He just wants her money. Wants her to die. Oh, look, we saw her smile. She's in there. We know she's alive. So publicized and so litigated that I can picture and ultimately, a court decided that Terry Schiavo would not want to be kept alive all of those artificial supports were removed and she was allowed to die. Now, if she had had a healthcare directive that said, my spouse makes my decisions, and if I am at a terminal state, I wish to be kept comfortable and allowed to die a natural death, none of us would know her name. Very, very, very likely wouldn't have gotten as far as it did. So who can make decisions? You can have more information speaking to what type of decisions you would want made on your behalf. You can even talk about comfort care wishes, burial wishes, all of that. And I'll give it, again, a few personal examples. So brother's in the hospital. Now, when he got put on an ambulance to get taken to Iowa City in Iowa, for some reason, one of the emergency responders had him sign a healthcare directive naming his wife to make his medical decisions. I haven't heard like a stroke of luck that it happened. I was visiting him in Iowa City, sitting in the hospital room with him. His wife comes walking in with the doctor, and I hear the doctor say, gosh, I'm glad they thought to have him sign that healthcare directive, because if he hadn't signed that, I wouldn't have been able to tell you all of that. I was honestly, in that moment, I was like, what? I mean, I know this stuff, right, intellectually, but to actually see it play out, I thought, oh my gosh, how stressful would it be for us to be in this situation and not be able to get every piece of information? My mom did her healthcare directive. She has a ton of details in it. She's a very particular woman. So like, I know that she wants to hear the Everly Brothers. If she can't, you know, she's about to pass and we're going to play music. I know what type of touch comforts her. I know what she would want for a memorial service. Those things I can't really put a value on in terms of knowing them. And it's become even more important to me because actually yesterday was 2 years since my dad passed away. And he passed away from early onset Alzheimer's on his 70th birthday. And there wasn't a lot of instruction. And even though I do this for a living, I'm an end of life doula in my personal life and I volunteer in hospice. It was like my brain went blank. And so a week later, I'm sitting at my house thinking, oh my gosh, why didn't we play George Thorogood? Why didn't we put on ZZ Top? Why didn't I rub his feet one last time? Like there were just these things that I didn't think of in the moment, which my mom has really detailed out. So if I'm overcome with grief, which I'm sure many of us know, man, does grief affect your brain? I didn't know that until 2 years ago. To that page. The last thing I'll share about healthcare directives is we did actually use my father's healthcare directive to support him in dying comfortably. And he passed away, he was not on hospice, and it was drawn out, it was long, like 5 days, and we were asking for more pain meds to be administered, and the doctor, who's not a hospice provider, they kind of have different approaches to pain meds, would not administer them. No, this could cause him to die sooner. And after 5 days, I was like, we wouldn't do this. You know, can we please support him? We all know what's happening here. So I got a copy of his healthcare directive, and in his healthcare directive, it said, if I'm in a terminal state, I wish to receive pain management as much as I can, even if it hastens my death. So I took it to the doctor and I said, you know, very respectfully, I want to show you this. This is in his healthcare directive. Could we please administer more pain meds? They doubled it. And so very passionate about healthcare directives, if you can't tell, and they are very, very important to have. So why have an estate plan? My kind of tongue-in-cheek answer is if you're 18 years or older. Once we turn 18, people aren't authorized to make these decisions on our behalf, especially healthcare and financial. If you're parents, if you're single, there's kind of different reasons. Couples who are not legally married, very important to have these documents done. Blended families, elder clients, and vulnerable adults. The important thing about elder and vulnerable, people can only sign documents when they have legal capacity to sign them. So I've had clients call me and say, can you meet with my mom? She needs these documents. She's been in memory care for 10 years. If you want to make things simpler for your family, and bottom line, if the state law is not going to do what you want, and in place to state what you want. And now Cindy's going to wrap up by talking about tax filing requirements.
Just quick, because this is what bores. I just wanted to talk very quick. I always get this question: what is an inheritance tax and what is an estate tax? Well, an inheritance tax is what you as the beneficiary would pay on anything that you would inherit. Not very many states. I think there's about 6 states that have an inheritance tax, and Minnesota is not one of them. We have an estate tax. An estate tax is what the estate pays on the value of the estate. It's not paid by the beneficiary. So a lot of times I'll get that question from people: do I have to pay inheritance tax? I just got money from my parents. Well, what state do you live in? You know, that would answer that question. And then I'm not going to go over all the details, but these are different returns that are required for when somebody passes away. As the tax person, I always want to let people know that the different forms that would be required or not required depending on the value of the estate. And with that, we're at our time, and I want to thank everybody for attending.